So there's a new world court on the scene. It's being created by the African Union, and, it's designed to be one of the most powerful international courts ever. But there's a catch. A rule so controversial that it could literally change how we think about global justice. Let's get into what that really means.
Okay, so the first, most obvious question is why, right? Why go to all the trouble of building a brand new court when the International Criminal Court, the ICC, already exists? Well, the answer really boils down to a long, pretty tense relationship, a feeling across many African nations that the global justice system just wasn't working for them. So here's how we're going to break this all down. First, we'll look at that clash with the ICC, which led to this idea of an African solution. Then, we're going to dig into the details, what this new court can actually do, its single most controversial rule, and finally, what this all could mean for the future of international justice everywhere. All right, to really get this, we have to start right at the source of all the tension, the relationship between the African Union and the International Criminal Court over in The Hague.
You see, for years, a lot of African Union member states have been saying that the ICC is unfairly zeroed in on Africa. They point to things like the indictment of Sudan's sitting president Omar al-Bashir as proof that the court was being used for political reasons. A real feeling started to grow that the ICC was basically a tool for Western powers, so much so that some AU documents called it a blatant abuse of the principle of universal jurisdiction. All that frustration created this massive push to build an alternative.
And that alternative was a court built by Africa for Africa. So how did this idea actually come to life?
Now, this didn't just happen overnight. The idea of a regional court system has been floating around since the 60s, but it really started to pick up steam after the African Union was formed in 2002 with a much more hands-on mission. The real turning point, though, was in 2014. That's when the AU adopted something called the Malabo Protocol. And that was the key. It was the legal move that officially added a criminal law division to the existing African court, paving the way for everything we're seeing today.
The whole project is really built around this one powerful idea: African solutions to African problems. It's all about regional ownership and self-determination. The argument is that this court can create a justice system that really understands the continent's unique context, like, for example, the need to secure peace before pursuing justice after a conflict.
And what's really unique is how the court is designed. It's not just for criminal cases. It's a 3-in-1 institution. As you can see, it has sections for general affairs, for human rights, and for international criminal law. Seriously, no other international court rolls all three of these things up under one roof.
Okay, this brings us to one of the most incredible things about this new court: just the sheer scale of its power. Its jurisdiction is absolutely massive.
A side-by-side comparison really shows you how different this court is. The ICC, on the left, it focuses on what they called the 4 core international crimes: genocide, crimes against humanity, war crimes, and aggression. The African court, it covers all of those and then adds this whole laundry list of other crimes that are hugely relevant on the continent: terrorism, piracy, corruption, money laundering, drug trafficking, and even the unconstitutional change of government. This is a gigantic expansion of what international criminal justice usually deals with.
But along with all that expanded power comes the single most debated, most criticized, and honestly, the most politically loaded part of this entire court.
This is it, Article 46A bis, and it says, flat out, that no sitting African Union head of state or government or other senior officials can be prosecuted by this court while they're still in office. This is a direct shot at the ICC for going after leaders like al-Bashir.
Now, to get technical for just a second, the legal term is immunity ratione personae, and it's really about timing. It's a procedural rule. It doesn't mean a leader can never be held accountable. It just means they can't be prosecuted while they're in power. They could absolutely still face charges after they leave office. So think of it as a temporary shield, not a get-out-of-jail-free card forever. But even a temporary shield is a huge deal. It creates this fundamental split in the world of international law. The ICC, in its founding document, made it a central point to remove immunity for everybody, no matter who you are. The African court puts it right back in place for serving leaders. These are two completely opposite philosophies on whether power puts you above the law.
So, of course, this immunity clause kicks up some really serious questions about the court's own credibility. Is this thing really a tool for justice, or could it just become a shield to protect the powerful from facing it?
To get the debate, you have to understand this key concept called complementarity. It's the bedrock of the whole ICC system.
It basically means the ICC is a backstop, a court of last resort. It's only supposed to get involved if a country's own courts, or in this case a regional court, are genuinely unwilling or unable to do the job themselves.
So the big fear among critics is that the African court could be used to game the system. A country could say, oh, don't worry, we're handling this case, but that pesky Article 46A bis would mean no prosecution could ever happen, which would effectively block the ICC from stepping in. It could create a two-tiered system, justice for regular people, but immunity for those at the very top. Now, on the other side, proponents argue this is vital for protecting sovereignty and stability, and that it prevents politically motivated cases from tearing a country apart.
All of this leads us to a much bigger, more profound question about where international justice is actually headed. You can really think of this court as a fundamental fork in the road. It represents two competing ideas, one that pushes for universal accountability, where nobody is above the law, and another that prioritizes regional control and the absolute protection of national sovereignty.
And there are two very, very different futures that could come out of this. In one version, the African court becomes an amazing partner, going after crimes the ICC can't touch, like corruption and trafficking, and strengthening the whole system. But in the other version, that immunity clause creates a loophole, a protection racket that undermines the entire global justice project and leads to conflict instead of cooperation.
Ultimately, the African court is a massive test case. And it leaves us with this final critical question to think about. As more regions might start to build their own courts, will they become pillars that hold up the global system of justice, or will they create fractures that could cause the whole idea of accountability for all to crumble?